Hello, 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 check, hello, yeah, yes, yes, the voice is here. Hello, check. So we'll wait for some time. Yeah, yes, yes, the voice is here. Yes. So we'll wait for some time. Yes, yes, So hi everyone, it is almost 3 p.m. now, and we are going to continue with what we had left in the last video. In the last lecture, we did up to Article 100, that is voting in House, power of houses to act notwithstanding vacancies and quorum. And from on to today, we are going to do from Article 101. So let's go a little below. Yeah, so we are going to start with Article 101, which is uh, in regard with disqualification of members. The section starts from here, and you can see on the screen there is, we have chapter number, we have vacation of seats, article 101, article 101, which states that, what does article 101 states? It states that vacation of seats, no person shall be a member of both houses, and provision shall be made by parliament. So the provision, that is the law, will be made by parliament by law for the vacation by by a person who is chosen a member of both houses his seat in one or other houses. So parliament will regulate if chosen in the both houses, and if chosen in both houses, what could be the case. All right, it is very simple, article 101. Now let's go to article for second clause of 101, that is, no person no person shall be member of both houses, no person shall be member of both houses, no person shall be member of both houses of parliament and of a house of legislature of a state, and if a person is chosen a member of both of parliament and of the house of legislature. So if somebody who becomes MLA, if somebody becomes MLA or MLA or MLC, or simultaneously becomes an MP, then at the expiration of such period may be specified in the rules made by the president. All right, made by the president, that a person's seat in parliament shall become vacant unless he previously resigned seat from the legislature of the state. Okay, so if somebody is MLA or MP and does not decide which seat they want to take, this 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 that is the Lok Sabha or Rajya Sabha, that is the parliament seat becomes vacant. It becomes vacant and he becomes an MLA. Okay, so rule specified made by the president, and the power is with parliament. Power is the parliament. All right. Third, clause 3. Clause 3 is what? If a member of either house of parliament becomes subject to any of the disqualification mentioned in clause 1 or clause 2 of article 102. Okay, so we'll see what 102 is. What is 3b? It says that resigns his seat by writing under his hand, addressed to the chairman or the speaker, as the case may be, and his resignation is accepted by the chairman or the speaker, as the case may be. Alright, very simple, nothing too difficult in this. Okay, then provided that in case of any resignation referred to in subclause B, in this subclause, if from information received or otherwise, and after making such inquiry as he thinks fit, the chairman or the speaker, as case may be, satisfied that such resignation is not voluntary or genuine, shall not accept. So again, very basic, that the speaker or chairman can accept and can reject as well, Okay, so let's go to clause 4, that is, if for a period of 60 days, that is very important to remember, 60 days, the member of either house of the parliament is without permission of the house absent from all meetings thereof, house may declare seat vacant. Okay, house may declare the seat is vacant, provided that in computing the said period of 60 days, no account shall be taken of any period during which the house is prorogued or is adjourned for more than 4 consecutive days. Okay, so if 4 consecutive days house is adjourned or prorogued, then 60 days would not be counted. Then 60 days, that 4 days, 60 days should not be counted. Alright, let's go to 102. 102 is what? Disqualification of membership. A person shall be disqualified for being chosen as and for being a member of either houses of the parliament if he holds any office of profit under government of India. Okay, so if he holds any office of profit, okay, it has mentioned office of profit, but it has not defined what is office of profit. Okay, so constitution has mentioned office of profit, but has not defined what all constitutes, what all elements of office of profit would be. It has not been mentioned. It has just mentioned office of profit under government of India or government of any state or any other office declared by parliament by law not to disqualify its holder. Okay, so if a law is made by parliament passes a law which states that these positions in these governments, these positions XYZ, for example governor position, for example position of any other appointments, vacancies, positions, that the parliament decides that these positions will not fall under office of profit, then the law cannot disqualify that. Then law cannot be disqualify that member. Okay, if he is of unsound mind. Okay, unsound mind, first case we have unsound mind can be a reason for disqualification and stand declared by competent court. Okay, so competent court has to decide. All right, this is disqualification. If he is an undischarged insolvent. Okay, this is the second case. Okay, first case was unsound mind, we have to remember this. Then we have second case, that is if he is an undischarged insolvent. All right, then we have the third one, that is if he is not a citizen of India or has voluntarily acquired the citizenship of a foreign state or under any acknowledgement of the allegiance and adherence to a foreign state. Okay, so even allegiance is written. Okay, it is not only acquiring citizenship but also allegiance. All right, so you have to remember this, the fourth point. Okay, first is office of profit, then we have unsound mind, undischarged solvent, foreign state, then we have disqualified by law made by any law made by parliament, Okay, then explanation is given. For the purpose of this clause, a person shall not be deemed to hold office of profit under government of India or government of any state by the reason that he is a minister of either union or such state. Okay, so if it is a minister, and that is not considered as office of profit. Okay, let's go ahead. A person shall be disqualified from being a member of either house of the parliament if he is so disqualified under 10th schedule. Okay, very important, 10th schedule. We know Airam Gairam case and how it eventually evolved. This case evolved into 10th schedule, how 10th schedule was formed. We will see when we look at schedules, and we will try to remember the order of what all happened in the formation of 10th schedule. Alright, then we have 103, decision on the question as to disqualification of members. Okay, so if any question arises as to whether a member of either house of parliament has become subject to any of the disqualification mentioned in clause 1 of article 102, the question shall be referred to decision of president. Okay, so clause 1 was what? Clause 1 of 102 clause 1 was what? It was regarding office of profit. office of profit, office of profit. So whatever the case may be, but any question has arisen whether that a person, a member of parliament, has an office of profit in another state or any other central government, the question shall be referred to president and his decision shall be final. Okay, so it can't be questioned further in the court. It cannot be questioned in the court, and the president's decision shall be final, which is mentioned in article 103, which is mentioned in 103 clause 1. Okay, let's go to 103 clause 2. Before giving any decision on any such question, like the decision that president will take in regard with office of profit, the such question the president shall, it is written shall, you should know shall means must, it is not, it is obligatory, it is not an option, it is not an option, not an option, it is a must, because it is written shall obtain the opinion of election commission and shall act according to such opinion. So the president is bound by the advice of what advice the election commission gives to the president acts accordingly in case of office of profit. Very important, previous year question has been asked again, that president acts when it comes to office of profit. Okay, so 104, penalty for sitting and voting before making an oath or affirmation under article 99 or when not qualified or when disqualified. If a person sits or votes as a member of either house of the parliament before he has complied with the requirement of article 99, or when he knows that he is not disqualified, or that he is disqualified for membership thereof, or that he is prohibited from so doing by the provisions of any law made by parliament, he shall be liable in respect of each day on which he so sits or votes a penalty of 500 rupees recovered from debt of the duty. Okay, all right. So it says that if somebody is not a member or disqualified or not qualified and sits in the proceedings, what are the penalties for that person shall be applied. Okay, now after 104 we have one important articles that are in regard with powers, privileges, immunities of parliament and its members. Again, very important PYQ, very PYQ topic. UPSC has been asking questions about privileges and immunities again and again, both in mains and prelims, so we have to clearly see it, what is it all about. Okay, article 105 says powers, privileges, etc. of houses of parliament and of the members of the committees thereof. So the powers and privileges are not only of the member of the parliament but also the members of the committees as well. Okay, subject to the provisions of this constitution and to the rules that and standing orders regulating the procedure of parliament, there shall be freedom of speech in parliament. Okay, subject to provisions of constitution. So the reasonable restrictions in article 19, reasonable restriction, and the rules of standing orders regulating the procedure of parliament. So the rules of parliament, other than that, there is freedom of speech in the parliament. No member of parliament shall be liable to any proceedings. So no member shall be liable to any proceedings in any court in respect of anything. Okay, so these are extreme words, you might get confused. Okay, so any court, any proceedings, anything said or any vote given by him parliament or any committee thereof, and no person shall be liable in respect of publication by or under the authority of either house of any report, paper, vote or proceedings. So lot of immunity given, lot of privileges given to member of parliament and the members of the committees thereof in this 105 clause 2. Okay, now 105 clause 3, in other respects the powers, privileges and immunities of each house of parliament and of the members and of the committees of each house shall be such as may from time to time be defined by the parliament by law. Again, so the privileges and immunities of each house of parliament are defined by it is written, are defined by parliament by making a law. They have to pass a law, they must have passed a law, you have to find out which law have been passed for this. Okay, until so defined. So they have defined it some privileges, so we'll see what are they later on. All right, let's go to 4, that is 105 clause 4. Okay, the provisions of clause 1, 2, 3 shall apply in relation to person who by virtue of this constitution have the right to speak in and otherwise take part in the proceedings of the house house of parliament or any other committee thereof, as they apply to relation to member of parliament. So this states that folks like people like attorney general, who by the virtue of this constitution have the right to speak and participate in both houses, and in committees they are member nominated as member of. All right, so this states that not only the member of parliament but any other person who by the virtue of this constitution are allowed to take part and speak in the proceedings also have similar immunities and privileges. 106 is salaries and allowances. Member of either houses of parliament shall be entitled to receive such salaries and allowances as may from time to time be determined by the parliament. Okay, so this question can be asked again: who determines the salaries and allowances of the members? UPSC might try to confuse you by writing president or by writing committees, but remember, it is in the constitution that determined by the parliament by making a law. All right, so several laws has been made in this regard again and again, time and again. All right, so let's go to 107, provisions as to introduction of passing of bills. All right, very important. These are I think the bedrock of legislative procedures in India, and across all states also these procedures are followed. So this is very important to understand them, how bills are introduced, how it is passed, what is different kinds of bills, and how they are approached in the parliament. Okay, so 107 is provisions as to introduction of and passing of bills, subject to the provisions of article 109 and 117 with respect to. Okay, so 107 already has exception, that is exception are 109 and 107. It states subject to the provisions. Okay, so the provisions of 109 are different from 107. So 109 and 117 are exceptions to 107. With respect to money bills and other financial bills, a bill may originate in either house of the parliament. Okay, so 109 is money bill and 117 are financial bills. So other than these two, all bills may originate in either house of the parliament, subject to the provision of 108 and 109. Okay, a bill shall not be deemed to have been passed by by the houses of parliament until it has been agreed by both houses. Okay, so a bill will be passed only when both houses agree to it, either without amendment or with such amendments only agreed as by both houses. All right, a bill pending in parliament, this has been a previous year question again and again. A bill pending in parliament shall not lapse by the reason of prorogation of the house. So prorogation is when the session ends. Right now budget session is going on. When the session will end, the house will be prorogued sine die. So the pending bill does not lapse just because house has been prorogued. Remember, the keyword is prorogued versus dissolved. Because they are going to confuse you by writing a pending bill in the parliament shall not lapse by the reason of dissolution of the house. So remember, here the keyword is prorogation. Okay, a bill pending in council of states, that is in Rajya Sabha. A bill pending in council of states which has not been passed by the house of the people. So if there is a bill which is pending in Rajya Sabha and has not been passed by the Lok Sabha, shall not lapse on the dissolution. In this regard, the word is dissolution of house of the people. So it does not lapse. Okay, remember that. A bill which is pending in the house of people. Okay, so now the bill is pending in Lok Sabha, or which having been passed by the house of people. Okay, so either the bill is pending in Lok Sabha or has been passed by Lok Sabha, is pending in council of state, shall subject to provision of lapse on the dissolution. Okay, so it will lapse on the dissolution. So two cases are in with regard to dissolution. Okay, two cases are in regard to dissolution, and one case is in regard with prorogation. So you should remember the difference here. We have prorogation here, we have dissolution here, and also we have dissolution here. So three cases on how the bills react. Okay, so let's go to 108. 108 is joint sitting. Okay, so how to remember it in? So 8 is like this. This is posture in which we sit. This is the asan, and in this joint sitting, you can remember joint sitting is 108. This is infinity, joint sitting. If after a bill has been passed by one house and transmitted to the other house, the bill is rejected by other house. The houses have finally disagreed as to the amendments to be made to the bill. Okay, so first house has passed it, but second house has rejected it. It can be anyone. Okay, both houses have disagreed to the amendments. Okay, more than 6 months has elapsed from the date of reception of the bill by the other house without being bill passed. Okay, so house 1 sent it to house 2, that is, for example, Rajya Sabha sent it to Lok Sabha. Rajya Sabha passed the bill and sent it to Lok Sabha, but Lok Sabha took more than 6 months took. So then it can go to joint sitting. So how does it happen? You can see the president, okay, so president will do it. Remember that president will do it. President, unless the bill has elapsed by the reason of dissolution of the House of the People, notify to the houses by message if they are sitting, or by public notification if they are not sitting, his intention to summon them to meet in a joint sitting for the purpose of deliberating and voting, provided that nothing in this clause shall apply to money bill. Okay, so this means it is written in constitution in clear writing that money bill does not lead to joint sitting. Joint sitting cannot happen in a money bill. In reckoning any such period of 6 months is as to refer to in clause 1 of no account shall be taken any period during which the house is referred to clause prorogued, adjourned, or more than 4 consecutive days. Okay, so the 6 months time that we calculate, if a house is adjourned or prorogued more than 4 consecutive days, then the time is not counted. It's as simple as that. Nothing complicated in this. All right, nothing complicated in this. Then we have 3, that is clause 3, where the president has under clause 1 notified his intention of summoning the house to meet in a joint sitting, neither house shall proceed further with the bill. Okay, so president has notified his intention of summoning the houses for joint sitting. Okay, president has decided that there will be joint sitting, then the both houses cannot proceed further with the bill, but the president may at the time after the date of his notification summon the both houses to meet for joint sitting for the purpose specified in the notification. If it does so, the house shall meet accordingly. All right, very simple, nothing complicated again in this. If at a joint sitting of two houses of the bill, such with amendments, if any as are agreed in the joint sitting, is passed by a majority. Okay, so how does it pass? By a majority of the total member of the both the houses present and voting. Okay, so you should remember that is the total members present and voting. That is the majority of total members of present and the voting. It shall be deemed to be proposed for this constitution to have been passed by both houses. Provided joint sitting, if a bill having been passed by one house has not been passed by the other house with amendments and returned to the house in which it originated, no amendments shall be proposed to the bill other than such amendments made necessary to the delay of the passage of the bill. If the bill has been so passed and returned, only such amendments as aforesaid shall be proposed to the bill, and such other amendments as are relevant to the matter with respect to house have not agreed. Okay, so these two are also very important. What kind of amendments can be introduced during the joint sitting? Okay, a joint sitting may be held under this article, and a bill passed thereat, notwithstanding a dissolution of the House of People, has intervened since the president notified intention. Okay, so this is very important. For example, Lok Sabha is dissolved. Lok Sabha is dissolved after president decided to hold joint sitting. After president. So again, let me explain. So if president says joint sitting, president says we need to do joint sitting, but after he is saying that the Lok Sabha falls and is dissolved, then also joint sitting can happen. It says a joint sitting may be held under this article, and a bill passed thereat, notwithstanding that a dissolution of the House of the People has intervened since the president notifies intention to summon the houses. So the new Lok Sabha comes, that will do the joint sitting. Okay, it is as simple as that. Okay, Let's go to the 109. What is 109? Special procedure in respect to money bills. Very, very important previous year question. I think 2025, 2024 they had asked questions about money bill. Direct question 109, 1010 they had asked. Okay, in prelims. A money bill shall not be introduced in Council of States. It is written clearly that Rajya Sabha cannot, that is Council of States cannot introduce a money bill. Okay. What is the clause 2? It states after the money bill has been passed by the House of the People, it shall be transmitted to Council of States, that is Rajya Sabha. So Lok Sabha will pass it, then send it to Rajya Sabha. That is House of the People will send it to Council of States. Okay. For the recommendation, and the Council of States shall within the period of 14 days. So there is a catch here. We have 14 days only. So Rajya Sabha only has 14 days. Rajya Sabha only has 14 days here. From the date of the receipt of the bill, return the bill to the House of the People with its recommendation, and the House of People may thereupon either accept or reject all or any. Okay, so Lok Sabha can reject or accept any of the recommendation of Council of States. If the House of the People accepts any of the recommendation of the Council of States, the money bill shall be deemed to have passed by the both of the houses with amendments recommended by the Council of States and accepted by House of the People. Okay, so Lok Sabha introduces money bill, passes it, sends to Rajya Sabha, and within 14 days Rajya Sabha sends back to Lok Sabha with recommendation. Lok Sabha accepts it or rejects it, and then bill is passed. Fourth is, if the House of People do not accept any of the recommendation of Council of States, so the Lok Sabha says that whatever recommendation in regard with money bill, we are rejecting these money recommendations from Rajya Sabha, then the money bill shall be deemed to have been passed by both houses of the Parliament in the form which was passed by the House of the People without any of the amendments recommended by the Council of States. Okay, so without any amendments of the Council of States, the bill is passed. If a money bill passed by House of the Parliament, House of the People, and transmitted to Council of States for its recommendation is not returned to the House of the People within the said period of 14 days, it shall be deemed to have been passed by the both of the houses in the expiration of said period. So if Rajya Sabha does not send back in 14 days, the bill is passed as passed by the House of the People, that is Lok Sabha. So you can see Article 109 gives extraordinary powers to Lok Sabha. So Lok Sabha in regard with money bill. Let's go to 110, that is definition of money bill. So okay, so first they have explained, so you can see it is usually definition should be first and then the special procedure, but 109 has explained the special procedure with money bill, and after that they have defined what are money bills. Okay, so 110 is definition of money bills. For the purpose of this chapter, a bill shall be deemed to be money bill if it contains only provisions dealing with all or any of the following. So it can be all of them together in any bill or any one of them in a bill. So for example, if a bill is introduced in Lok Sabha which has any one of them, for example which has something related to that, like they are alteration regulation of any tax is going on, so this will be a money bill. For example, if the custody of consolidated, the consolidated fund will be finance minister if they says some bill is brought, so that will be a money bill. So any bill which deals with any one of them or all of them is called a money bill. So what are these cases? First is imposition. You are imposing. Imposition, abolition, remission, alteration, regulation of any tax. Okay, the regulation of the borrowing of money or the giving of any guarantee by Government of India or the amendment of law with respect to any financial obligation undertaken or to be undertaken by the Government of India. Okay, the custody of consolidated fund, contingency fund of India, the payment of money into or withdrawal of money from any such fund, appropriation of monies out of consolidated fund, declaring of any expenditure to be expenditure charged on consolidated fund. So the expenditure charged on, we had discussed in the previous video on Parliament what is charged on expenditure. What is charged on expenditure? So if there are any changes in what kind of expenditure is charged on, for example, if they make a joint service public commission, if they make a joint service publication and they say the salaries of the commission members shall be charged on the Constitution of India, then it will be called a money bill, because it is declaring that this particular expenditure is an expenditure charged on consolidated fund of India. Should remember this word, charged on. Charged on is very important. this word charged on consolidated fund of India or charged on constitution, you can say that is very important, is very important. even even it is says that increasing the amount is also money bill. Increasing the amount of charged on consolidated fund of India is also a money bill. Okay, now we have the receipt of money on account of consolidated fund of India or the public account of India or the custody. Okay, so receipt of money, we are receipt of money, consolidated fund of India or the public account of India or the custody or issue of such money or the audit of account of the union, any matter incidental to any of the matters specified in subclause A to F. A bill. Okay, so let's look at the two. Let's look at the two. That is, a bill shall not be deemed to be money bill by the reason only that it provides for the imposition of fines. Okay, so if there is an imposition of fine, it shall not be deemed as money bill, or other pecuniary penalties, or for the demand or payment of fees for licenses, fees for services rendered, or by reason that it provides for the imposition, abolition, remission, alteration, regulation of any tax by any local authority or body for local purposes. So you should remember this line, that this that if there is an imposition, abolition, remission, alteration, or regulation of any tax by local authority, or local body, then it is not money bill. Then it is not a money bill. If any question arises whether a bill is a money bill or not, the decision of the Speaker of the House of the People shall be thereon be final. Okay, so the Speaker of the House of People, that is the Speaker of the Lok Sabha decides whether a bill is a money bill or not. There shall be endorsed. Okay, so what shall be endorsed? This shall be endorsed, right? The Speaker of the Lok Sabha has to endorse by means he has to sign on every money bill when it is transmitted to the Council of States. Okay, so if there is a bill that is transmitted to Council of States, the Speaker of the Lok Sabha presented the Parliament assent for it, the certificate of the Speaker. There is there is something called certificate of the Speaker, which is signed by the Speaker, stating that this is a money bill. The Speaker has to endorse it. The Speaker has to, very very important, clause 4 of 110. Now we have to see assent to bills. When a bill has been passed by houses of parliament, it shall be presented to the president, and president shall declare either he assents, which means he says okay the bill is passed, or he withholds. Means he is not giving his assent. Provided that president may, as soon as possible after the presentation to him of the bill for assent, return the bill if it is not a money bill. Okay, so in case with money bill, president cannot return it, but in case with other bill, return the bill to the houses with a message requesting that they reconsider the bill or any specified provisions thereof, and in particular will consider the desirability of introducing any such amendment as he has recommended in his message, and a bill is so returned, the house shall reconsider the bill accordingly, and if a bill is passed again by the houses with or without the amendment presented to the president for the assent, the president shall not withhold. Okay, so in case with ordinary bills, if president sends back these bills, then they have to either pass it with what the amendments he has suggested, or they can without that send it back, and the president then, once again when it is sent to the president, he cannot withhold. He cannot say I am not giving assent to this particular case. Alright, so let's look at 112, annual financial statement. This is one of the most important, that is the budget that happens. It is annual financial statement. The president shall, in respect of every financial year, cause to be laid before both houses of the parliament a statement of the estimated receipts and expenditure. So it is written as estimated receipts and expenditure. So these are two separate documents in the budget. When we see the budget document, we have to do these as well. Okay, of the government of India for that year, and this part is referred as annual financial statement. The estimates of expenditure embodied in the annual financial statement shall show separately. So okay, so the Constitution of India specifically mentions that what should be shown in the annual financial statement, that is the budget. Okay, So it states that the sum required to meet expenditure described by this constitution as expenditure charged upon. Okay, again we have expenditure charged upon. It is very important word, charged upon, charged upon, charged upon consolidated fund of India. So the annual financial statement as the budget must mention that this particular expenditure, this particular part is charged on the Constitution of India. The sum required to meet other expenditure proposed to be made from the consolidated fund of India. The sums required to meet other expenditure proposed to be made from the consolidated fund of India and shall distinguish. Okay, so the B part is what is the required expenditure proposed to made from the and shall distinguish expenditure or revenue account from the other expenditure. Okay, so that's why we have revenue expenditure and capital expenditure and all other aspects in budget, because the constitution mandates that we need to have expenditure, revenue account and other expenditures. The following expenditures shall be expenditure. So the constitution has mentioned some of the expenditure that shall be charged on, Constitution of India. That is, first is the enrollments and the allowances of the president and other expenditure relating the office. Then we have salaries and allowances of the chairman and the deputy chairman of council of states, that is Rajya Sabha, speaker and the deputy speaker of house people, that is Lok Sabha. Okay, debt charges, it has mentioned all of these points. Okay, debt charges. Okay, so if government of India has taken or any other loans have been taken, government of India is liable, including interest, sinking fund charges, redemption charges and other expenditure relating to the raising of loans and other services, redemption of debt. Then we have salaries, allowances, pensions payable to the respect of judges of the Supreme Court. Pensions. Okay, so you can see the difference here. Supreme Court salaries are also consolidated fund of India. Supreme Court salaries, allowances and pension, all of three are for Supreme Court. But in case with the federal court, we don't have a federal court. Let's look at the third one, that is the pension payable or inside. So for the judges of the high court, only the pensions are only pensions are from consolidated fund of India. Consolidated fund of India, only pensions are there for high court, because their salaries are paid from consolidated fund of states. Their salaries are paid from consolidated fund of states, but their pensions are paid from consolidated fund of India. As it is written, it is charged upon. Okay, and the salary, allowances and pensions payable in respect to CAG. Okay, so CAG salary, allowances and pensions are payable, are also charged upon. Then we have any sums required to satisfy any judgment, decree or award or any court and arbitrary tribunal. So any for example, government usually court says that this particular organization has to pay this much amount to this person, the victim of this person. So where does the money come from? All of these money is charged upon the constitution, charged upon the consolidated fund of India, which means that they don't need to vote on this. The Lok Sabha does not need to vote on this. Okay, any other expenditure declared by this constitution or the parliament by law to be charged, charged. Okay, so if constitution or the parliament declares by law that this particular expenditure is charged on, then it will be called charged upon the consolidated fund of India. Let's look at 113, procedures in parliament with respect to estimates. So much of the estimates as relate to expenditure charged upon consolidated fund of India shall not be submitted to the vote. So 113 explains that whatever expenditure is charged upon, you remember this, charged upon, shall not be submitted to vote in the parliament, but nothing in this clause shall be considered to preventing discussion. Okay, so voting, they need not do voting on the charged upon expenditure, but they can discuss, discussion can happen. All right, let's go to next, that is 113 clause 2. So much of the said estimate as relates to other expenditures shall be submitted in form of demand of grants. So other than the expenditure charged upon the consolidated fund of India, all other expenditures shall be submitted in the form of demand for grants. Okay, demand for grants, you should remember that, demand for grants. Okay, demand for grants, it is submitted to House of the People, and the House of People shall have power to assent or to refuse to assent as to assent any demand subject to reduction or amount specified therein. No demand for grant shall be made except on the recommendation of President. Okay, so no demand for grant shall be made except on the recommendation of the President. Okay, we'll see what are demand for grants, how they work, how the ministries send it to finance ministry for, and then finance ministry bring the bill budget, and then the demand for grants are brought in. The whole process of it we'll see when we see budget. But you should remember that other than the charge upon expenditure on consolidated fund of India, all other expenditure are made in form of demand for grants. It is mandated in the constitution. Okay, let's look at appropriation bills. Okay, as soon as maybe after the grants under the 113 has been made by the House of the People, there shall be introduced a bill to provide for the appropriation out of consolidated fund of India all the money is required to meet. Okay, so demand for grants have been made in the parliament, and then after that appropriation bill comes. That is to provide for appropriation, like to get the money out of, what does appropriation here means? To get money out of consolidated fund, required to meet the grant so made by the House of People. So whatever money can be withdrawn from the consolidated fund of India shall be as made by the House of the People. The expenditure charged on the consolidated fund of India, but not exceeding any other carried amount shown in the statement previously written. So whatever the charged on expenditure has been laid by the government in the parliament shall be only that much amount shall be taken from the consolidated fund of India. So these are two cases for how money is taken out of consolidated fund of India. Let's go look at clause 2, 114 clause 2. No amendment shall be proposed to any such bill in either house of the parliament which will have the effect of varying the amount or altering the destination of any grant so made, or of varying the amount of any expenditure charged on the consolidated fund of India, and the decision of the person presiding whether the amendment is admissible or not shall be final. Okay, so speakers, that is Speaker of Lok Sabha's decision will be final whether any amendment to such a bill which varies the amount, alters the destination of the grant, or varies the amount of charged on consolidated fund of India shall be admissible. Such amendment shall be admissible in the house or not. This will be decided by the Speaker of the Lok Sabha. Alright, let's look at the third clause. Subject to the provision of 115. Okay, so there is an exception, 115 and 116. No money shall be withdrawn from consolidated fund of India except under the appropriation by law passed by accordance with the provision of this article. So appropriation bill has to be passed, and only after appropriation bill is passed the money is withdrawn from consolidated fund of India. Only after that money can be withdrawn from consolidated fund of India. Let's look at what is 115. Supplementary, additional and excess grants. So these are also previous year questions. Supplementary, additional, excess, these are three different kind of grants. Okay, these are three different kind of grants that are there. The president, okay, so these grants, the president shall, if amount authorized by any law made in accordance with the provision of article 114 to be expended for a particular service for the current financial year is found to be insufficient. Okay, so for example, highways, road transport ministry say for a project, for something, they think that this money is insufficient, and for the purpose of that year, when the need has risen during the current financial year for supplementary or additional expenditure. Okay, so all money has been spent by Ministry of Road, then upon new service not contemplated in the financial budget. Okay, so this is what supplementary or additional expenditure when there is insufficient, when the amount is found to be insufficient. If any money has been spent on any service during the financial year in excess of the amount granted for that year. Okay, so there are two, supplementary or additional, then we have excess, that money has already been spent. In this case, money has not been spent and was not accounted for. Okay, cost to be laid before both the House of the Parliament. Another statement showing that estimated amount of that expenditure cost to be presented House of the People, a demand for such excess as case may be. Okay, so in this, after the money has been spent, it is presented to the House of the People and Parliament. The provisions of Article 112 and 113 and 114 shall have effect in relation to any such statement and expenditure or demand, and also to any law to be made authorizing the appropriation of monies out of consolidated fund of India to meet such expenditure or grant in respect to such demand as they have effect in relation to annual financial statement and the expenditure mentioned therein, or to demand or grant and the law to be made for the authorization of appropriation money out of consolidated to meet such grant. So this is saying all of the whatever we have read in 112, 113 and 114, what effect it will have, what effect will we have in relation to annual financial statement. Okay, nothing, not very important. Let's look at 116. Let's look at 116. Vote on account, vote on credit, exceptional grants. These are also previous year questions. They've asked questions on vote on account, vote of credit and exceptional grant. Okay, so there are three. Notwithstanding anything in the foregoing provision of this chapter, the House of the People shall have power to make any grant in advance. Okay, so make any grant on advance in respect to estimated expenditure for a part of any financial year. So it is not for the entire financial year, but a part for, let's say, 3 months. Let's say, for example, 3 months, not for entire 12 months, that is financial year, but 3 months, part of, pending for the completion of the procedure prescribed in 113 for the voting of such grant and the passing of the law according to the provision of to that expenditure. To make a grant for meeting unexpected demand. Okay, unexpected demand upon the resources of India when on account of the magnitude or the indefinite character of the service demand cannot be stated with the details ordinarily given in financial statement. For example, there is a war, let's say, then the details cannot be given in the financial statement, that this much money is spent on this much money spent or there much money spent, then we use this, this is to make an exceptional grant which forms no part of the current service of any financial year. So if it is not mentioned in any of the financial statement or grants, then it is called exceptional grant. So this is vote on credit, this is vote on account, this is vote on account, and this is exceptional grant. These three are there. You should know the differences between these three. Okay, it is as it is in the constitution. And Parliament shall have power to authorize by law the withdrawal of monies from consolidated fund of India for the purpose of the above said grants made. Okay, the provisions of 11314 shall have effect to in relation to making any grant. So again it is saying the relation with respect to appropriation and etc. So we can ignore that. Let's go to 117. Very important and always confusing. This is one of the most difficult bills in article in my perspective, because 1171 and 1173 are one of the most confusing clauses of the constitution in my perspective. Okay, a bill or amendment making provisions to any of the matters specified in subclauses A to F of clause 1 of article 10 shall not be introduced or moved except on the recommendation of president, and a bill making such provision shall not be introduced in council of states. So we already know that a bill or amendment making provision for any of the matters specified in subclauses of A to F of clause, that is article 10 is money bill, article 10 is definition of money bills. So A to F of clause 1, that is constitutes what all kind of money bills are there, what all constitutes money bill. Okay, it states that provisions shall not be introduced in Lok Sabha provided that no recommendation shall be required under this clause for moving an amendment making provision for reduction or abolition. Okay, so there were the reduction and abolition. If there is happening an reduction or abolition of tax, then recommendation of president, is not required. Let's go and look at 1110. What does 1110 says? Because 117 has an exception for 1110. Okay, so 1110 says that it first imposition, abolition, remission, alteration, regulation. So there is no reduction or abolition here, right? Reduction and abolition are not mentioned in 1110. Reduction or abolition of tax are not mentioned in 1110, but it is mentioned in 117. That it is mentioned in 117, as you can see, it is mentioned that no recommendation is required of the president. No recommendation in this case 117 is required under this clause for moving an amendment making provisions for the reduction or abolition of any tax. So for example, if an amendment is moved which states that there needs to be a reduction or abolition of any tax, then president's prior recommendation of president is not required. You should remember, reduce करने के लिए for reduction or abolition president's recommendation is not required, which is the case when bringing out money bill or amendments to the money bills. Okay. A bill or amendment shall not be deemed to make provisions for any matters aforesaid by the reason only it provides for the imposition of fines. Okay, again the same thing, that it shall not be imposition of fine or any pecuniary penalties for the demand of payment of fees, licenses, or fees or services rendered or the by reason provides for the imposition of abolition, remission, alteration, regulation, or tax by local authority. Okay. Then we have the third, which is very important. A bill which, if enacted, brought into operation, would involve expenditure from Consolidated Fund of India, shall not be passed by either House of the Parliament unless President has recommended to the House consideration of the bill. Okay, so remember that this is a very important exception here, because this is not President's recommendation to introduce the bill. This is not talking about President's recommendation to introduce the bill, but this is talking about consideration of the bill. Okay, so there is a difference between introduction. For that, usually President's recommendation are required in certain bills. Okay, so President recommends it, and after that the bill is introduced in Lok Sabha or Rajya Sabha. But here in 1173, it is not talking about President's recommendation for introduction, but is talking about President recommendation for the bills to be considered to be passed. Okay, so when the voting will happen, President's recommendation is required, because for the considering of the bill, it is written for President's consideration. Oh, consideration of the bill, President has recommended. So you must read the difference between 1171 and 1173, because this is really confusing, and it needs to be really crystal clear in order to make differences. We will do this again from other resources, not the constitution directly, when we see budget and financial bills. Okay, rules of procedure. Each House of Parliament may make rules for regulating subject to the provisions of this constitution, its procedure, and the conduct of its business. Until rules are made under clause 1, the rules of the procedure and the stating orders in force immediately before the. So this is saying that rules and procedure of the Lok Sabha and Rajya Sabha. President after consultation. So this is when rules were not made, how rules would be followed. The President after consultation with the chairman, House of the People, may make rules to subject or joint sitting के लिए, for the joint sitting may make rules. Okay, at a joint sitting of the two houses, the Speaker of the House of the People, and in absence two house a joint sitting of the two houses, the Speaker of the House of the People, or in his absence such person may be determine the rules of procedure. Okay, so it is written in regard with 108 that when there is a joint sitting, the House of the Speaker of the House of the People, that is the Speaker of Lok Sabha, presides the joint sitting, or any other person determined by the rules of procedures. Okay, let's go to 119, that is regulation by law of procedure in Parliament in relation to financial business. Parliament may, for the purpose of timely completion of financial business, regulate by law the procedure and the conduct of business in each House of Parliament in relation to any financial matter, or to so financial matter, or to any bill for the appropriation of monies out of Consolidated Fund of India, and if so far as for any provision law made been consistent with any rule made by Parliament or against rules standing order have effect relation to Parliament. Okay, so we do not need to worry what is it is saying, because I also don't understand it. Language to be used in Parliament. Okay, 120, very important. Notwithstanding anything in part 17. Okay, so we need to see what is part 17. You check out what is part 17. But subject to the provision of 348, business in the shall be transacted in English, Hindi or English. It is written Hindi or English. You should remember it is written in the Constitution. Provided that the chairman of the Council of States or the Speaker of the House of the People, that is the chairman of Rajya Sabha or the Speaker of the House of the People or person acting as such as case may be, may permit the member who cannot adequately express himself in Hindi to do in mother tongue. Okay, so you can also do it in mother tongue. You can also participate in your mother tongue unless Parliament by law otherwise provides. The article shall, after the expiration of period of 15 years from the commencement of this constitution, shall have effect word English were omitted therefrom. So it was in the original constitution stated that after 15 years English to be omitted, but we still using English. Okay, let's go to 112. Let's go to 112. 121. 121. That is 121. That is restriction on discussion in Parliament. No discussion shall take place in Parliament with respect to conduct of any judge. Conduct of any judge. Okay, so no discussion can take place in regard with conduct of any judge of Supreme Court or of High Court in the discharge of duties except upon a motion of presenting an address to the President praying for the removal. Okay, so the conduct of judges of Supreme Court or High Court cannot be discussed in the Parliament, except when the address president for the removal of motion for the removal is under consideration. 112. Courts not to inquire into proceedings. The 122, the validity of any proceedings in the Parliament shall not be called upon question. Okay, so in this case the conduct of judges is not discussed in Parliament, and in this case courts do not inquire into the proceedings of the Parliament, so they are not interfering in court, and they are not interfering in court is not interfering in Parliament. The validity alleged irregularity of procedure. So if there is somebody says that there is an irregularity of procedure in Parliament, it shall not be called upon question in the court. No officer or member of Parliament whom in whom powers are vested by or under the Constitution for regulating procedure or the conduct of business or for maintaining order in Parliament shall be subject to the jurisdiction of any court and exercise those power. You can understand it. It is very simple. Okay. Now let's look at legislative power of the President. Legislative power of the President. Power of the President to promulgate ordinances. So 1, 2, 3. Ordinances, very important. Ordinances, if at any time except when both of the houses are in session, so at any time, but if the house is session, not then, except the President is satisfied that circumstances exist, so satisfaction of President, which render it necessary to take him immediate action, he may promulgate ordinances and the circumstances appear to him require. An ordinance promulgated under this article shall have the same force as effective act of Parliament. But every such ordinance shall be laid before both houses of Parliament and shall cease to operate at the expiration of 6 weeks. Okay, should remember ordinances only last for 6 weeks. That is 1.5 month. 6 weeks. Okay, from the reassembly of Parliament, or if before the expiration of that period resolution disapproving it are passed by both houses upon passing the second of those resolution. Okay, so if before 6 weeks they pass a resolution that this ordinance is removed, may be withdrawn by at any time by President. Where the houses of Parliament are summoned to reassemble on different dates, the period of 6 weeks shall be reckoned from the later of those. Okay, so if Lok Sabha is summoned on this date and Rajya Sabha is summoned on that date, so the later date would be considered. If and so far as ordinances under the article makes any provision which Parliament would not under this constitution be committed. Okay, so ordinance cannot make provisions which Parliament don't have power to. Okay, so all ordinance can only make those laws which powers has been given to Parliament from the Constitution. Okay, so we will stop here. Because this ends the Parliament. this ends the parliament, this ends the parliament. And after that we have the judiciary. We have different chapters, that is judiciary. So we will stop here and we will go to some important aspects. We'll close this down, we'll close this, and we'll go to we'll go to we'll go to the materials that we have with this is material from vision. These are some documents from vision. All of these are online available, you can refer to these, and these are very helpful. I have read them multiple times, and these are online available. You just write parliament and you write vision and you'll get these. You can simply see these are three, I think 3 or 4 parts are there, and these are not very big documents. This is 9 page, this is 13 pages, and this is 7 pages, and there is I think one more which is a little bit longer. And this is very graphic, and you can see how many members are there, what are territorial constituencies after census, readjustment, reservation of seats, first past post the system, duration of 2 houses, membership of parliament, qualification, disqualification, ground or defection, vacating of seats. Then we have oath and affirmation, salaries and allowances, presiding officers. We have presiding officers. So all of these are there in these documents. You can find. We are going to do it. No, but not today. I'm going to show you some other things today, and we are going to see these later on when we do another rounds of revision. These are parliament, so you can see a day in parliament. You can see a day in parliament, it states a day in parliament. I will show. I was a lamb fellow. I had worked as a lamb fellow, and I had closely observed parliament for more than 1 year. I had in fact worked inside parliament, filing questions, filing 0 hours, 377 notices, etc., etc. All of these motions I have filed. So I understand the working of the parliament, daily routine of the parliaments, and I'm going to cover it in detail in the next upcoming videos. But just to make you see what all things you have to read, I'm just showing you where I have read it from. These are latest, I think these are updated. A lot of information are there, so you can check these out by yourself. You can go to vision, you can just google vision is parliament procedures. You will get all of these documents. Okay, so what we are going to do today is I'm going to show you the websites of Lok Sabha and Rajya Sabha. Okay, so most of us do not see these websites. These are very interesting website. They have earlier the website used to be very old, and these used to be very basic, but now they have upgraded it to something crazy. They have updated to something crazy. Let me reduce this. Maybe I think. So this is the website of Lok Sabha, as you can see. And we have to, what we have to do is we have to go to committees. We'll go to committees, and from committees I'm going to do show you is the various committees that are part of Lok Sabha and Rajya Sabha. And very important, very important, why, what are committees, how does committees work. So you can see parliamentary committees, it is mentioned here. It is mentioned, as you can see this. Let me increase, maybe I think increasing it would help. I don't know how to. Yeah, I think I have to go here somehow. Let me uh, let me yeah. Yeah, so you can see parliamentary committees, the work done by it is mentioned what kind of uh, it is mentioned what kind of work parliament does. It is they have explained it whatever they are doing. So membership and tenure of parliamentary, you can see here they have mentioned financial committees. Okay, can you see it? Can you see it? I think, I hope you can see it. They have mentioned financial committees. They have mentioned right here financial committees. There are three financial committees, that is committee on public undertaking, estimates committee, public accounts committee. So you should remember three financial committees, number of members 22. Okay, so 22 in both of them. And estimates committee we have 30 members. Okay, in estimates committee we have 30 members and elected by Lok Sabha. Estimate committee 30 members, Lok Sabha. Rest of the two committees, that is the public account committee and the committee on public undertaking, are elected by both of the members, both of the houses, of members from both of the houses. Okay, let me reduce size a little bit, maybe then it will be visible. Is it not visible? I think it should be visible now. Let me check. Okay, so you can see they have mentioned financial committees, departmentally related standing committees. So we have 24 department standing committees covering jurisdiction various ministries, consist of 31 members, 21 from Lok Sabha and 10 from Rajya Sabha. So departmental standing committees has 31 members, in which 21 members are from Lok Sabha and 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 10 members are from Rajya Sabha. So then there are other standing committees. We have business advisory committee. As you can see here, right here we have business advisory committee. We have 15 members, nominated by Speaker Lok Sabha. As you can see right here, the nomination is Speaker Lok Sabha. Committee on privileges 15, not fixed. Absence of member 15. Then we have ad hoc committees on MP-lad, committee on provisions. Then we have function of committees. Okay, so all of these are information is available on Lok Sabha website, you can check out yourself. Let's look at financial committee section. Okay, let's just click here, financial committees. So you can see they are showing three financial committees. Let me readjust this on screen keyboard. Let me readjust this, and so that it comes nicely. I want to show you. Yeah, I think it is visible now. And it is going out. Okay, so let it be. So you can see financial committees, they have mentioned estimates committee, public account committee and public undertaking committee. So if we click at estimates committee, it shows that who is the chairperson. It shows a little document about, they have mentioned a document about the committee. The committee on estimates, constituted for the first time in 1950, is a parliamentary committee consisting of 30 members elected. It has also mentioned that what is the term of office, functions, working. Then we have whole aspect of achievements, etc., etc. They have mentioned here as well. Okay. Similarly, if we go to back to financial committees and we look at public accounts committee, you can see who is the chairman. Then you can see the little bit history about the committee. Parliamentary democracy like ours, committee system, genesis of committee 1921. You can see 1921 right here, as you can see right here 1921. So it is one of the oldest. It is mentioned in the Lok Sabha websites that in the wake of Montague Chelmsford reforms, okay, 1921. Okay, then we have constitution. How is it constituted? Since independence, scope and functions. What are the functions? You don't need to remember all of them, but you can read them. You can read them and understand the nature of these committees and what are kind of. I think one reading would be sufficient, and a crisp notes you can make using. ChatGPT. Okay. Okay. So this is the committee work. Then we have financial. Then if we look at financial committees, third, we have to see all the financial committees because only 3 financial committees are there. You can see, and then we have public undertaking. You can see who is the chairperson and what are the oh, see, there is a document, committee on public undertaking. So 22 members are there. They have mentioned it really nicely. Functions, working of the committee. Then we have some other aspects, how it has worked. Okay. So you can use this source. Then we have other committees like department standardization committees. If you go, you can see agriculture, animal husbandry, chemical fertilizers, coal, mine, steel, defense, energy, external affairs, finance, consumer affairs, communication, labor, textile. All of them are there. So you don't need to go into each of them. You can see summary of work. You can go to introductory guide right here. Yeah, they have mentioned introductory guide, and you can read this document. It's a huge document. You don't have to read all of it. You can summarize it using ChatGPT. Okay. Then we have other parliamentary standing committees. So other parliamentary standing committees. So absence of member, business advisory committee. This is a very important committee. Empowerment of women, ethics committee. Ethics committee was very much in news these days. Then we have general purpose committee, government assurances, house committee, office of profit, salaries and allowances, papers to be laid, library committee, petitions committee. Then we have rules committee, privileges. So privileges is also usually in news. Privileges committee is also very important, right? Then we have ad hoc committees. So you can see joint parliamentary committee, MP lad, etc., etc. All of these are ad hoc committees. Then we have other committees. Okay, so joint, etc., etc. A lot of committees are there. You don't have to remember these. Then we have joint parliamentary committees. That is the investigative committees. So there are a lot of investigative inquiry, Bofors, stock market. Then we have FSSAI, matters related to allocation of prices of telecom sectors. All that there, the special committees that have been made in the parliament are there. Okay. Now what else we can see? We can see the business. We can see the questions. Okay. So we can see the questions, general information. Okay, so it is right here, it is mentioned. See, this year the question was asked regarding start and unstart question. You can see start question, what are unstart question, what are short notice question, what are private members questions. Okay, so they have given complete details. What are the admissibility of the question, related to question, what are short notice, what are half hour discussions, and there is a group of allotment of question. All of these are mentioned right here, so you can check this out from the website of the Lok Sabha itself. All right, I am going to bring short documents on these as well. I think 1 pages would be enough to cover these. Then we have debate, wit and humor. You can see house business. I think that is all. Similarly, in the website of Rajya Sabha, you can go and check out the committees that are specifically for Rajya Sabha. These committees will be different from what are there in Lok Sabha. So you can just go through and them once. I think you will be able to understand. Just make notes of some of the important committees that are in news in the newspapers. I think that would be sufficient for the examination perspective. All right. Other than this, I think we are already, I think 80 minutes we are touching. So I think I am also going to stop now. and in the next video, we are in the next live stream. I hope this live stream was helpful, and even if it is not helpful for you, I think it is a kind of a revision that I did for myself as well, and those who were with me in the live stream. And I'm going to do it every day, and hopefully consistency will come, and I will make sure to bring some important and really interesting topics. So this is one of the boring topics that we have to do, because it is related with something that is very static, not very current oriented, not very evolving something. This is very static, and I was expecting it to be boring, and it is. I find it boring because I had worked here for 1 year, and all of this parliamentary legislative work, I think it is uh, very very slow. So, but we have to remember this. It is interesting nevertheless. So, I think that is enough for today, and I'm going to stop now. And hopefully, I would see you tomorrow at the same time, and we are going to do some more lectures. Tomorrow we are going to do environment, so I'm going to share with you some interesting aspects of environment. Okay,